wherein we had seen the out of the 5 modes of how an individual can gain citizenship, we have already seen the 4 modes, that is by registration, by birth, by descent, as well as by incorporation of a territory. So the 5th mode is by naturalization. The 5th mode is by naturalization. So any individual can also get citizenship by naturalization. How does an individual get citizenship by naturalization? You can write this. The central government on an application grant a certificate of naturalization, to any individual who possesses the following qualifications. First, he is not a subject of any country. He is not a subject or citizen. He is not a subject or citizen of any country where citizens of India are prevented from being subjects or citizens by naturalization, which means the law simply prohibits. Suppose there is a particular country which is either a monarchic or a democratic country, and in that particular country there is a provision that subject or citizen of any other country cannot become the citizen of that very country. So, or if a particular country has specifically been prohibited that subjects or citizens of this country cannot become a citizen of that particular country by naturalization. If that is not prohibited, or if that is prohibited, in that case that citizen or citizen of that country cannot gain citizenship of India as well. Clear? Second, citizen of any country renounces the citizenship of that country on his application of citizenship being accepted in India. So whenever an individual gets citizenship of India by naturalization, so if he is a citizen of any other country, he has to renounce or give up the citizenship of that very country. He cannot be the citizen of both the countries. If you remember, last class we had specifically discussed Article 9 of the Constitution, and Article 9 of the Constitution prohibits dual citizenship. So if you apply for citizenship of India and your citizenship is accepted here, you are to be given citizenship, you have to renounce the citizenship of the other country. Third, if the individual has either resided in India or has been in the service of the government throughout the period of 12 months immediately before applying for Indian citizenship, so an individual who has resided in India and or has worked under the government of India anywhere else also, but if they have been in service for 12 months, in that case they can apply for Indian citizenship. And finally the last point here.
Will that person be considered an OCI card holder?
No, that individual will not have OCI card holder. OCI card holder is an individual who has a very specific qualification. He is an individual of Indian origin and has applied for OCI card. If the individual has applied for OCI card and has been given OCI card by the government of India, only that individual is considered to be an overseas citizenship of India card holder. That's it. No one is assumed to be an overseas citizenship of India card holder. He is not assumed until unless the individual has that very card.
Exactly which service we are talking about?
Any kind of service under the government of India. Any kind of service under the government of India. Fourth, the last point here. An individual has stayed in India. An individual has stayed in India for 14 years, and out of the 14 years, 12 months immediately preceding the application, or is under the service of the government of India, under the service of the government of India for a period of 11 years. What does this provision mean? It means that in the last 14 years, if an individual has stayed in India, has resided in India for 11 years, in the last 14 years, if the individual has resided in India for 11 years, and out of this 11 year, 12 months, he has continuously resided in India for just preceding, that is just before he makes an application to the government for citizenship. Let's understand this by an example. Suppose an individual, taking this particular time frame, 2005 to 2019. Now this is 14 years. Out of the 14 years, that means today we are suppose in November of 2019. So from November 2018 to November 2019, he has to continuously stay in India. This 12 months he has continuously stayed in India. And since 2005 to 2019, this 14 years, he has stayed for 11 years in India. That is not continuously. That may be 5 years, he has stayed, or 2 years he has stayed, then he has he has gone to any other country, then he has come back, and out of that 14 years, if he has resided in India for 11 years, and before making an application for the last 12 months, he has resided in India continuously, in that case also the individual can be given citizenship by naturalization. Clear? Now, if you remember, in the last class we did say that the two categories, that is by registration and by naturalization, we do not consider them to be natural born citizens. We say they are naturalized citizens. They are not natural born citizens, they are naturalized citizens. And we also discussed that we do not differentiate between a natural born citizen and a naturalized citizen. Once an individual is a citizen of India, the individual has all the rights that any citizen of India is going to enjoy. The individual has all the rights that any citizen of India is going to enjoy. But there are some countries, like I gave you an example of a country like US, wherein only natural born citizens are given certain rights. Not all citizens enjoy similar rights. Naturalized citizens do not enjoy some rights. Like when we talk about constitutional offices cannot be occupied by naturalized citizens. They are to only be occupied by the natural born citizens. Like I gave you an example of how in US, when the last president Barack Obama, he became the president, so there was question about his presidentship on this very criteria also, because he was not born to a an American father. He was he had an his father had nationality of Kenya and his mother was an American. So there was question whether he was a natural born citizen or not. Then he produced his birth certificate, which actually laid down this controversy to rest. But in those countries, in country like US, and that is only one of the examples, there are so many other countries wherein natural born citizens that are there. That is, if you are, if you have citizenship by birth, or if you have citizenship by descent, or if you have citizenship by incorporation of a territory, in these three cases you are considered to be natural born citizens. And when you have you get citizenship on the basis of these criterias, you enjoy some more rights than any other citizens. Clear? But we do not do that. In India, this is not the case. We do not differentiate between citizens on the basis of these ideas. Clear? Absolutely clear? By registration and by naturalization, if you look at these two ideas, and before I have dictated what are the conditions for you to get citizenship by registration, or what are the conditions for an individual to become a naturalized citizen, I said the government of India may give you citizenship if you satisfy the following criteria, which means in the last two conditions, that is by registration and by naturalization, citizenship is not automatically given. That means if suppose I have fulfilled this criteria, that I have resided in India for the last 11 years, in the last 14 years I have stayed in India for 11 years, and out of that 11 years, 12 months consecutively before making an application, if I satisfy this also, I only have the right to apply for citizenship. Whether citizenship is given to me or not, it depends upon the government of India, because there are some other conditions also that the government might look into, because I am not a citizen of India. So in that case, there are some other conditions also on which the government may or may not provide for citizenship. So I have the right to only apply under registration, under naturalization. I have the right to only apply. I have the right only to apply for citizenship. Whether citizenship is given to me or not, it is upon the discretion of the government of India. Clear? Remember this, and that is the reason why they are called as naturalized citizen and not a natural born citizen. Any individual who is a natural born citizen, the individual has the right to citizenship. No, the individual has the right to citizenship. So if suppose an individual like us, we are natural born citizens. We are natural born citizens of India. So if we are born to Indian parents and in India, in that case the government will not deny us the right to citizenship. But if you are not a natural born citizen, even if you fulfill certain criteria for citizenship, you might not be given citizenship. Clear? This is the 5 modes under the Indian Citizenship Act of 1955 in which you can get citizenship of India. Remember, if you look at all these 5 modes, They are again based on those two laws that we had talked about in the last class. What were those two laws? Law of soil and law of blood. Just solely and just sanguine. So law of soil. So either you have resided in India, you will always find you have resided in India is being that is one of those criteria. So law of soil. If you have stayed in India for a period of 14 years, if you have served under the government of India, or if you are an individual of Indian descent, people of Indian origin. So now then you get citizenship, or you have resided in India, then you get citizenship. So law of soil and law of blood. These two are the basic ideas on which citizenship is granted in India. Whether you look at the Constitution of India, or for that matter, if you look at the Indian Citizenship Act, they all, no, both of them provide citizenship in this very case. Clear? Next, we come to termination of citizenship. That means how an individual may be, there are certain conditions in which an individual may be denied citizenship. So these are 5 modes in which an individual gets citizenship. There are 3 modes. 3 modes in which an individual may lose citizenship. So what are the 3 modes in which an individual loses citizenship? 3 modes in which an individual loses citizenship. First, by renunciation. By renunciation. By renunciation. That is, you can write, any citizenship, any citizen of India, any citizen of India can make a declaration, for renouncing his Indian citizenship. His Indian citizenship. It is a voluntary act. It is a voluntary act. However, if such a declaration is made during a war, it can be withheld. It can be withheld. See, generally what happens is that any individual who gets citizenship of any other country, if an Indian citizen is getting citizenship of any other country, Article 9 prohibiting dual citizenship in India, he cannot remain the citizen of India as well as the citizen of the other country. So what happens is he has to renounce his citizenship. So he renounces citizenship of India voluntarily, he gives up citizenship of India and then does what? Opts for citizenship of any other country. It is a voluntary act. By himself he is doing that. It is a voluntary act. Next, by termination. By termination. When an Indian citizen gets citizenship of any other country voluntarily and does not surrender Indian citizenship, his Indian citizenship is terminated by law. His Indian citizenship is terminated by law. So if you do not voluntarily renounce Indian citizenship but you get citizenship of any other country, that too voluntarily, you have gained citizenship of any other country, that means you have lost Indian citizenship. Your Indian citizenship is terminated by law. Clear? Like an example of it is M.F. Hussain. Going back around 10 years, M.F. Hussain, who was an Indian citizenship, he got the citizenship of a country in Middle East. He did not voluntarily give up citizenship of India, but he got citizenship of that particular country. He had applied for it and voluntarily accepted the citizenship of that country. So automatically his Indian citizenship was terminated. Clear? Any individual who gets citizenship of any other country does not renounce citizenship of India. The individual, it will not happen that the individual will continue with citizenship of India as well. It is automatically terminated. It is automatically terminated. Clear? Like during elections, you will find that generally this debate generally comes up that Rahul Gandhi is a citizen of British. There are number of cases, and this is something that comes up during every elections. That there is a question on his British citizenship. There is a question on his British citizenship, because if it is proved that he is a citizen of Britain, in that case automatically his Indian citizenship gets terminated. Automatically his Indian citizenship gets terminated. Clear? See, in war what happens is what is the reason for this provision? If you remember, what did I say? When I was introducing the topic citizenship, I said that citizenship is a legal relationship between the state and the citizen. And along with some rights, citizens have certain duties as well. So an individual might give up his citizenship just to escape that duty. That is, to enter into war, because we know that the state can force individuals to provide service in war. When there is a service, when there is a war that is going on, in that case the individual can be forced to provide service in war. In that case, an individual to give up, just to escape from that, he might give up his citizenship. So that cannot be done. That is the only reason. Clear? Finally, the third criteria is by deprivation. By deprivation. By deprivation. If a person has obtained citizenship, by means of a fraud, concealment of facts, or misrepresentation of facts, or on some other grounds, the individual may be deprived of his citizenship. So if an individual gets citizenship by a fraud, so he has lied, or he has concealed some facts, or he has misrepresented some facts, or in certain cases if he is disloyal to the country, or in such circumstances an individual can also be deprived of his citizenship. Clear? These are the three modes in which an individual loses his citizenship: by renunciation, by termination, and by deprivation. Clear? Next, give a subheading, right? Overseas citizenship of India. Overseas citizenship of India. In the background of the adoption of LPG, liberalization, privatization and globalization, when India opened its market to the world, in that case there were some, because of LPG, India wanted to invite various individuals, citizens of some other countries and also certain other institutions to come and invest in India. In this background, the demand for dual citizenship in India started. That these foreigners that are investing in India, they were demanding that, like the citizens of India whose property rights are legally protected in India, we should also be given citizenship, because only then our rights are also protected. Our property rights, whatever investments we take up, our investment rights, it would be protected under the law. Because going back to the original constitution, and whenever we talk about property rights or investment rights, the investment and property rights of an Indian citizen in India is protected by a means of a law. That means once you are an individual, once you gain that Indian citizenship, in that case you can legally, you are legally identified as a citizen here, and thereby you can enter into a contract to sell, to buy property, or for that matter take up investments. So in this background, because the foreigners and the Indian diaspora who were living abroad, who were citizens of some other countries, they were not citizens of India, but yes, they were of people of Indian origin. So they started demanding that India should also amend its constitution. Thereby, India should also provide dual citizenship, like some of the other countries that are there, like US and in Europe also. Majorly in US and Europe, the idea of dual citizenship is very much accepted. So in US you would find there are individuals having dual citizenship. They are all citizens of US, they are also citizens of some other countries. That is very much allowed. That is very much allowed there. And this is also something that was a prevalent norm, that is a prevalent norm in the European countries. In Europe, many of the countries, they accept for not just dual citizenship, multiple citizenship, which means if you want, you can become citizen of not that but only that country, but 2 or 3 other countries as well. This is a very accepted norm in Europe. So on the basis of this idea, Indian government also started contemplating whether should we amend the constitution and provide for dual citizenship. And thereby in the year 2000 itself, there was a committee that was formed under the chairmanship of L.M. Singhvi. And the committee recommended that India should amend its constitution and provide for dual citizenship. However, this citizenship law was not amended. The constitution was not amended, and Article 19 was still Article 9 was also the same original article which prohibited dual citizenship. But what we did was, we came out with a separate category of citizens. A separate category of citizens, or more appropriately, a separate entities that we recognized in terms of their investment and property rights that were recognized in India. We did not provide them with citizenship of India. We just recognized them as legal entities and protected their property and investment rights in India. Those entities are called as Overseas Citizenship of India card holders. Clear? OCI card holders. They are not citizens of India. They are not citizens of India. They are those individuals who have been legally recognized by us as individuals whose property, investment and some other rights are given to them, but they are not considered to be Indian citizens. So they do not enjoy all the rights that we enjoy. No, they do not enjoy all the rights that we enjoy. Like, they do not enjoy the right to vote under Article 326. They do not enjoy the right to hold constitutional positions. Like what is mentioned under Article 58, under Article 66, under Article 157, under Article 165, under Article 76 of the Constitution, or under Article 124. All these articles deals with certain constitutional offices. Constitutional offices like the President of India, the Vice President of India, the Prime Minister or the Council of Ministers, the Governor, the Chief Minister or the Council of Ministers, the Judge of the High Court or the Supreme Court. All these constitutional offices that are there, the OCI card holders, they are not those individuals who can or who are automatically who automatically get they can become this part of these offices, or they can hold such offices. No, they cannot. Similarly, they are also not given rights under Article 16 of the Constitution, which provides that when the state is providing public employment, it will not discriminate among citizens on certain grounds, which is mentioned under Article 16 of the Constitution. That right is also not extended to the OCIs. They have certain rights such as their investment and property rights are protected in India. They can stay in India without a visa for an unlimited period. They also have the right to carry an Indian passport. They also have the right to carry an Indian passport. They have the right to enter and go out of India without any visa. They can, at any point of time, they can enter India if they are an OCI card holder, or they can leave India if they are an OCI card holder at any point of time without requiring any visa for that. Or for that matter, when it comes to education and these higher educational institutions that are there, in these higher educational institutions, they are given some specific rights. No, they are given some specific rights, like you must have heard about something called as an NRI quota. No, NRI quota in higher educational institutions, there are some NRI quota that is there, and under that quota they have to pay a higher fee, but they get admissions into such educational institutions. They do not have to enter into those the examination, etc., competitive examination. No, there is an NRI quota that is there, and through an NRI quota an individual gets the individual automatically gets admission in such institutions. These rights have been extended to the OCIs, but they are not given Indian citizenship, because once an individual becomes a citizen of India, then the individual has all those rights. Right to vote, right to hold constitutional offices, right to get into public employment, all these rights are there. But those rights are not extended to the OCIs. Those rights are not extended to the OCIs. See, when I say Article 16, what I mean is only public employment. It does not mean that they do not have the right to employment in India. They can enter into employment in private sector, they can work in private sector, they can work in whichever sector, but they will not get an opportunity to get into public employment, that is employment of the government of India. That will not be provided to them. Otherwise, they all enjoy the right to work in India. That is definitely there. Clear? This was a change that we made through an amendment in 2003, which was implemented in the year 2004, and currently in India, all countries except for Pakistan and Bangladesh, that means who are citizens of Pakistan, they do not have the right to become OCI card holders in India. Similarly is the case for a country like Bangladesh. An individual from Bangladesh also will not be given OCI card holder. Previously, this was also the case for Sri Lanka, but later on an amendment was done and Sri Lanka was removed out of that list. So today, an individual who is a citizen of Sri Lanka can be given an OCI card in India. Clear? Have you understood this? So it's all the decision that is there, it is basically in the background of LPG, the demand for investments in India, and the demand by the Indian diaspora, specifically living in the western part of the world, to for India to take up dual citizenship. But rather than opting for dual citizenship, India has come out with a third category called as the OCI. There is a difference between an OCI and an NRI. What is that difference? How do we legally define an NRI? Non-resident Indian. How do we legally define an NRI? Who is an NRI? How do you become an NRI?
Person of Indian origin living in abroad.
No, that is not the definition of NRI. Any individual who is of Indian origin might not always be an Indian citizen. NRI means non-resident Indian. He is an Indian, not residing in India. The legal definition of an NRI is that if there is an individual who has stayed outside the country for more than 183 days in a year. No, 183 days, 182, 183 days, if he has stayed outside India, in that case, he becomes an NRI. He becomes an NRI, which means approximately 6 months. If you have stayed outside India for 6 months, you are an NRI. You are an NRI. You are Indian citizen. You enjoy all the rights that an Indian citizen has. But you have been classified as a different kind of a citizen, non-resident Indian. This classification is legal only because there is some tax rebate and tax exemptions that are given to NRIs. So any individual who has an NRI, he is exempted from income tax in India. He is exempted from income tax in India. So whatever he earns from outside, whatever he brings to India, it is completely, absolutely tax free. That is the only reason why we have legally recognized the idea of NRI. Now, there are two other terms. One is OCI and PIO. You must have heard about something called as PIO. Who is a PIO? PIO is a people of Indian origin. That means their forefathers, parents, grandparents or great grandparents, they were Indians. All those individuals who belong to this category, they were Indian, they were Indians, but now they are no more an Indian. So they have been residing in any other part of the world. They have now the citizenship of those countries. They are PIOs, people of Indian origin. They are people of Indian origin but not Indian citizens. They are not Indian citizens. OCI also, this idea of OCI card that is given, they are given to PIOs. That is any individual who is of an Indian origin but has been residing somewhere else. No more has Indian citizenship. If he wants Indian citizenship, so rather than giving him Indian citizenship, or if he does not want to give up citizenship of any other country, in that case, rather than opting for Indian citizenship, you can come into a very different category called as Overseas Citizenship of India card holder. Clear? So who are OCIs? They are people of Indian origin, but they are not Indian citizens. They have been given some specific rights that generally Indian citizens enjoy, not enjoyed by foreigners, but they have been given those rights. But they are not Indian citizens, and that is the reason why they do not enjoy all the rights that are given to Indian citizens. Clear? Absolutely clear who is an OCI? आप पूछो.
So for NRI it is 183 days continuous in 1 year.
No, 183 days in a year, where it can be continuously, it can be otherwise also. Clear? Understood this idea? Now, right, OCIs. This category of rights was created in the year 2003. In the year 2003, for people of Indian origin for people of Indian origin living in 16 specified countries. 16 specified countries. Later, this eligibility was extended to countries other than Pakistan, Bangladesh and Sri Lanka. Pakistan, Bangladesh and Sri Lanka. Currently extended to all countries except Pakistan and Bangladesh. Pakistan and Bangladesh. The OCIs are not full-fledged citizens of India. The OCIs are not full-fledged citizens of India. They are foreigners. They are foreigners who have been given some special rights. Who have been given some special rights which are not available to other foreigners. Which are not available to other foreigners. They enjoy the following rights. They enjoy the following rights. First, they are allowed to carry an Indian passport. They are allowed to carry an Indian passport issued by the government of India. Issued by the government of India. Second, they do not require a visa to enter India. Third, they are allowed to stay in India. They are allowed to stay in India for any length of time. Next, their investments and property rights are fully protected. Their investments and property rights are fully protected, which is equivalent to rights of Indian citizens. And last point, they are given preferences in higher education. However, they do not enjoy the following rights. That is, right to vote. Second, they cannot contest elections. And occupy constitutional offices. And third, they do not enjoy fundamental rights under Article 16 of the Constitution. Clear? So this is about the overseas citizenship of India. See, the idea was very logical and thereby it has been created. This very idea can be considered to be an example of how the constitution has evolved. Now previously the history, the background in which India gets independence, that provided, no, the background provided for India to implement a very stringent laws with respect to citizenship, because we all know we had that partition, and partition the consequences of partition that was there, all this, looking into all these things, there was stringent laws that had to be implemented with respect to citizenship. But now we have created a different category of citizenship or different category of rights, and an individual who becomes an OCI gets these rights. This is just an example of how our constitution evolves, how our constitution has evolved. Looking into the contemporary times, looking into that, how it has evolved. Coming to the last part of our discussion under citizenship, that is Citizenship Amendment Bill. Give a subheading, right? Citizenship Amendment Bill. Citizenship Amendment Bill. See, this Citizenship Amendment Bill that is there, this Citizenship Amendment Bill is considered to be an amendment bill that was proposed in the year 2016. So it is called as Citizenship Amendment Bill 2016. It is called as Citizenship Amendment Bill 2016. However, currently the Home Minister of India has said that we are going to bring about this law. Now we are going to introduce this law again in the Parliament. Why am I saying again? Because this bill was introduced in the year 2016. It was passed in the Lok Sabha, but the bill was not passed in the Rajya Sabha. Why? Because it was never taken up for debate, discussion and voting in the Rajya Sabha. It was never taken up, and that is the reason why it remains an amendment bill of 2016. If it is introduced again in the new Lok Sabha, the Lok Sabha that we have created in the year 2019, if it is introduced in the new Lok Sabha, then it will be known as Citizenship Amendment Bill 2019. Clear? It will be then known as Citizenship Amendment Bill 2019. But currently this has not been the case. Currently this has not been introduced in the Lok Sabha, or for that matter the Rajya Sabha. So we will still consider it to be Citizenship Amendment Bill 2016. Clear? So you have to make that change. If the bill is reintroduced, and if the name of the bill changes 2019, then you also have to make that change in the whatever you are writing here. Clear? Now, what have you heard about this particular bill, Citizenship Amendment Bill? What have you heard about this Citizenship Amendment Bill? Belonging to 3 countries, any individual who has come from that particular 3 country will get citizenship in India. Minorities, they would get citizenship in India. 6 religious minorities get citizenship in India if they are living in India for 6 years. Anything else that you want to add here? No, that is the reason why they have come to India. Anything else that you have to add here? Technically speaking, it is not any individual or any individual who belongs to these minority groups coming to India. It is about those individuals who are illegal migrants. They are illegal migrants. Now, if you remember, from our previous discussion of citizenship and whatever we have discussed as of now, this idea proposes the fact that when it comes to citizenship in India is to be provided by whatever mechanisms, even if it is to be provided through naturalization or by registration. It is to be provided only to those individuals who are legal migrants and not illegal migrants. If you are an illegal migrant in India, you have come to India in a manner that has not been recognized by law, which means you don't have visa, you don't have the permission, you don't have a passport which stamps the date of your arrival, or for that matter, if you visit your country, so when the day that you have visited or something like this, in that case, you do not have citizenship rights. You do not have citizenship rights even if you have stayed in India for 20 years. Like NRC was implemented in Assam, and with the implementation of NRC it was recognized that there are the last draft that was there were certain somewhere around 2 million people who were recognized to be illegal migrants. They were recognized to be illegal migrants. Some of them have been living in India for more than 40-50 years, but they have been recognized as illegal migrants. So if you go by citizenship laws, any individual who has stayed in India for that 11 years out of the 14-year period, that individual can apply for Indian citizenship. लेकिन इन्होंने तो अप्लाई नहीं किया है सिटीजनशिप के लिए. Why? Because they have not been legally staying in India. They have not been legally staying in India. Their stay in India is illegal. If you could have come to India, you would have been allowed to come to India legally. If you have come to India through, suppose, a visa or something like that, in that case, that is a different thing. For that, it's not that the government is trying to throw away every individual who has even come to India legally. That is not the case. Why they have been recognized, and why are we talking about they staying in detention centers, not being allowed to work, all these things that we are talking about. Why are we talking about these things? Because their stay in India is illegal. Their stay in India is illegal. They are illegal migrants, and illegal migrants in India do not have the right to citizenship. Even if they have stayed for, and even if they have satisfied all necessary conditions that has been mentioned under registration or has been mentioned under naturalization, even then they do not have citizenship rights. The Citizenship Amendment Bill that has been proposed, that Citizenship Amendment Bill gives rights to illegal migrants coming from certain countries who belong to minority section in those countries, and they have been prosecuted in those countries for being a religious minorities. For belonging to this very category, because they were religious minorities, they were prosecuted there, and that is the reason why if they have illegally come to India, in that case this Citizenship Amendment Bill says that if they have stayed in India for 6 years, then they have the they have the right to apply for Indian citizenship. Clear? Additionally, it also, the Citizenship Amendment Bill also says that it is going to amend the 1955 law, and overseas citizenship of India, OCIs, those individuals who are OCIs, if they have in India, if they have taken up any act which is illegal or which contradicts a law, in that case the individual can be denied of his OCI card holding status. This has also been mentioned under the new amendment bill. Clear? These are the only two provisions that are present. What are the controversy and criticism? We'll come to it. First write this. What are the amendments that are proposed? So just give a subheading here and write proposed amendments. Proposed amendments. First, it seeks to allow illegal migrants from certain minority communities such as Hindus, Sikhs, Buddhists, Jains, Parsis, and Christians coming from Afghanistan, Afghanistan, Bangladesh and Pakistan, and have stayed in India for 6 years, being eligible for citizenship in India. Second, the bill also provides that registration of OCI card holder may be cancelled if they violate any law. These are the two basic provisions. Underline 6 years, underline the 3 countries, Afghanistan, Pakistan and Bangladesh. Also underline the communities, that is, all the minority community, Hindu, Sikhs, Buddhists, Jains, Parsis and Christians. Underline that. Clear? So this is the basic provision that is there under the Citizenship Amendment Bill. Obviously, there are 2 or 3 things that are very clear from this. The first idea is that specifically, Muslims have not been mentioned here. In the law, you can see that it mentions Hindus, it mentions Christians, it mentions Sikhs, Parsis, Jains, Buddhists, but it does not mention Muslims. Second of all, it also comes up with a provision of 6 years. Currently, if you look at by naturalization, it says that an individual should have stayed in India for 12 years and 11 years. Out of the 1 year it should be consecutively, and out of the 14 years, yes, he should have stayed for 11 years. So currently the provision says 12 years. For this particular category, the amendment law says 6 years, not 12 years, rather it only says 6 years. Clear? So the provisions or the criticisms of the particular bill is very prominently present. First, it can be criticized on the grounds. That there are specifically Muslims who have been excluded here. The idea is that the Home Ministry says that when you look at countries such as Bangladesh, Pakistan or Afghanistan, Muslims are not in minorities there. So we have provided the law only for minorities in these countries, and accordingly Hindus, Sikhs, Buddhists, Jains, Christians, Parsis, they are basically minorities in these countries, in these 3 countries. So we have extended the provisions only for them, not for those individuals who are in majority in these countries, because they say that they have been prosecuted just because of their religion. The 6 communities that are there, they have been prosecuted because of their religion. So Hindus who were in Pakistan post independence 1947, if you look at the data is that there were around 16-17% of Hindus living in Pakistan. Today, currently, they are only 2%, less than 3% of them are remaining, which points out to the fact that there has been prosecution of Hindus. Similarly, in Afghanistan, similarly in Bangladesh, Hindus and Christians and individuals from these minority communities, they have been prosecuted because of their religion, and that is the reason why we are providing or making a provision for giving them citizenship. Clear? So this is the very idea. Though the criticism is that there is a discrimination that is being done, but the idea seems to be logical, that yes, because Muslims are not in minorities in these countries. They are in minorities in India. They are minority in India, but they are not in minorities in Pakistan, or for that matter, when you look at Bangladesh or Afghanistan. So religion has not been the mechanism or the reason for their prosecution. Even if even if Muslims have been prosecuted, so religion is not the ground then, and hence they have not extended citizenship amendment or provisions with respect to giving them citizenship. Clear? On the second hand is this this idea of cancelling OCI status. This can also be criticized because there have been cases in which certain individual who are OCI card holders, they are working in India and they may have an anti-government stand. Now they may have an anti-government stand, like lot of there have been some of the OCIs who are working in various NGOs etc. in India, and these NGOs, they have always considered that any government that comes to power, they do what? They misuse the power, the authority that they have against us. So this particular provision may also be misused by the government. This is the second criticism to this very idea. Clear? So discrimination as well as the misuse of the law. Write this. Criticism of the proposed amendments. Criticism of the proposed amendments. First, it violates the principle of equality, as illegal migrants are being distinguished on the basis of their religion, See, this criticism also stands very true. The reason is that if we go back to the 1970s or late 1960s and early 1970s, the Bangladesh war that happened, the basic idea of Bangladesh war was that the discrimination was not on the basis of religion. Discrimination was on the basis of race. Race was the basis of discrimination. That means the background of Bangladesh war was what? Mujibur Rahman, who was the leader of who was a political personality in East Pakistan. He was able to win almost all the seats in the East Pakistan. In the National Assembly of Pakistan, the seats that were allocated to East Pakistan, his political party was able to win all the seats in the parliament, which automatically made what? Which automatically made the this individual was to become, Mujibur Rahman was to become the next Prime Minister of Pakistan. But he was racially discriminated against. It was said that Bengali speaking Muslims who were Muslims who were short heighted, not fair in complexion. Yes, this was the basis. They were short heighted. They did not have that tehjeeb, क्योंकि वो उर्दू नहीं बोलते थे. They were speaking Bengali. They were not speaking Urdu. They were speaking Bengali. They were short heighted. They were not fair looking. They were not good looking. So how can these individuals, how can he become the Prime Minister of Pakistan? And that was the very basis. That was the very basis on which he was discriminated against. They were discriminated against, and rather than he becoming the Prime Minister of Pakistan, the Pakistani army, they sent their troops to Bangladesh and started human rights violation in this particular region. There were more than, it is considered that there were more than 5 lakh individuals who were killed, tortured, raped, etc., etc. So that was the very reason why they actually came to India. Now, when they came to India, why did they migrate to India? Even if it was illegal migration, it was on the basis of the prosecution that they faced. It was not religious. It was, it was the idea there was race. So when we talk about the when we talk about prosecution that is going on the basis of religion, what we have not considered is that it is not always the case, and the Bangladesh war is an example. But still, this has not been considered by the government of India. Second, it is perceived to be a demographic threat to indigenous communities. Demographic threat to indigenous communities. Basically, if you look at the Northeast, Northeast has faced, is facing this very problem. Like the state of Assam, and we have implemented NRC there, but that is not the only state which is suffering from demographic problems. Demographic problems have been present in the other states in Northeast as well. Like if you look at states such as Tripura, you would find that there was a data that was released which said that almost 30% of the population of the state are not indigenous to the state. They have migrated to this particular place. So this is also a very important idea that people coming from outside the country, and if they have been illegally residing in India, and when you provide them with citizenship, it means that even if they have, they are threat to local resources, local culture, local economic opportunities, but still you are considering them to you are ensuring that they become citizens of India. Now this is also something that is a criticism. Next, the bill makes illegal migrants eligible for citizenship. Illegal migrants eligible for citizenship if they have resided in India, for 6 years. The citizenship law currently provides 12 years as qualification for legal migrants. Which means what? The government is providing incentive to be an illegal migrant rather than being a legal migrant. So why not be an illegal migrant? 6 साल ही तो रुकना पड़ेगा. After that we are eligible for citizenship. So it is an incentive for being an illegal migrant rather than being a legal migrant. And the last provision the bill allows cancellation of OCI registration, for violation of any law, This is an ambiguous provision which can be misused. So any individual, even for minor offences, if suppose I am an OCI, so my OCI card holding status can be deprived. I can be deprived of that even if I have provided, or even if I have taken up minor offences. मतलब मैंने ट्रैफिक लाइट जंप कर दिया और मैं OCI हूँ, तो क्योंकि मैंने लॉ वायलेट किया है, and the law is not very clear what kind of violation, so I can be deprived of my OCI status. Technically speaking, this can be misused. Clear? This can be misused. So these are the criticisms of the proposed amendments under the 2016 bill. Clear? Absolutely clear. This is where we complete our discussion on citizenship. Going back till now, what have we discussed? We have discussed 3 basic provisions. We have discussed the preamble. Now we have discussed the preamble, and in the yesterday's test, if you have appeared for yesterday's test, I have asked questions on the preamble. जो भी मेरे mains वाले questions थे, they were all in preamble, on the basic ideas of the preamble. So I have we have taken up our discussion on preamble. The test has also been completed on the preamble. Some of those questions that were asked there, they were actually previous year question papers. No, from previous year questions. I'll try and include all the previous year question papers. So if suppose I am dealing with citizenship, so today I have completed citizenship. So if there has been any question in your previous year examination on citizenship, I'll try and include that in the weekend test. Clear? So we have completed preamble. We have completed the first part of the constitution, that is union and its territory. In that we have discussed Article 3 of the Constitution and Article 1 of the Constitution, which are the two most important ones. Then we have discussed citizenship. In citizenship we have taken up constitutional provisions. We have discussed Article 5, 6, 7 and 8. Then obviously Article 9 and Article 11. These are the articles that we have discussed. And then we have discussed Indian Citizenship Act, 5 modes of gaining citizenship, 3 modes of losing citizenship. And then we have also discussed something called as an OCI. 2004 amendment brought this particular idea. And finally we have also discussed a proposed amendment on the Citizenship Act. That is it. So basically we have completed all the necessary discussions that we can take up in the class with respect to citizenship. Clear? With this we complete part 2, citizenship. We come to part 3, that is fundamental rights. Fundamental rights. Now basically we have already talked about citizenship. We have defined citizenship as a legal relationship between the state and the citizen, and I did say that this legal relationship manifests itself in the form of rights and duties. ये legal relationship कैसे काम करता है? How does it actually work? This legal relationship works in the form of rights and duties, and accordingly part 3 of the Constitution provides for a set of rights which we call as fundamental rights. The question is, why are these rights called as fundamental rights? Why don't we just call it as rights? Why is it necessary to call them as fundamental rights, or why is the nomenclature mentioned as fundamental rights? Why not just mention rights? Like in the Constitution of US, you would find there is something called as Bill of Rights that has been mentioned. No, it is called as Bill of Rights. In India, why is it called as fundamental rights? What do you mean by they cannot be snatched away? What do you mean by that? Snatched away. Yes, they can be.
A person cannot be deprived of.
Yes. They can be taken away. These rights can be taken away. So how can you say this? What are you saying? आप कुछ बोल रहे थे ना? Same idea. Why is it called as fund? That is there with all rights. That is the case with all rights. How can you say some rights are available to some and not to all? That is the basic pillar when it comes to a democratic country. When you provide rights, you provide to all citizens, not to some of them. Discrimination is not the part of any democratic standard. It cannot be a part of any democratic standard. Why called as fundamental rights? सोचने वाली बात है. Why is it called as fundamental rights? Why not just right? Because when we say it cannot be snatched away, no rights can be snatched away. Legally speaking, if I have a certain right, like if I have something called as right to information, now that is a legal right, not a fundamental right. There is a law that was passed in the year 2005 and that provides us with the right to information. So in this case, I will be given that right at any cost till the time that law exists. I cannot be deprived. These are protected by the Indian Constitution. It is guaranteed by the Indian Constitution. Okay. Now, do you think the only reason why these are called as fundamental rights is just because it is guaranteed by the Constitution? So, why not, if that is the only right because it is guaranteed by the Constitution, in that case, if you look at Article 326 of the Constitution, Article 326 of the Constitution gives us the right to vote. Article 300 of the Constitution, 300A of the Constitution gives us the right to property. Why are they not fundamental rights? Because they are also guaranteed by the Constitution.
Essential for all-round development.
Yes?
They are essential for all-round development.
They are essential for all-round development. What do you mean by all-round development? Spiritual development, moral development, and he is absolutely correct. Why are they called as fundamental rights? Not just because it is guaranteed to us by the Constitution. It is guaranteed to us because it allows or it ensures an individual can develop to his fullest extent or fullest potential, and that is the very reason. So when we say it to be fundamental, why is it fundamental? It is fundamental because availability of these rights ensure overall development of an individual. What is meant by overall development? It means mental, spiritual, physical, or intellectual. And not just because it is available for or it ensures overall development, but it also ensures that we have an ideal democratic setup. That is, democracy. The existence of democracy in India is also dependent upon the existence or the availability of fundamental rights. If fundamental rights are not available to us, if we do not have the right to speech, if we do not have the right to association, if we do not have the right to movement, if we do not have the right to residence, if we do not have the religious rights that we have, if we do not have certain right to equality, in that case we cannot we cannot have this right of we cannot have this democratic or democracy that is in existence. It no more would be present. And the best example of it is if you look at a non-democratic country like China. In China, do you know that the Chinese constitution also talks about fundamental rights? The Chinese constitution also talks about fundamental rights. And what are the fundamental rights that are present under the Chinese constitution? There are two fundamental rights that are present under the Chinese constitution. The Chinese constitution says the fundamental right to work. So you have the fundamental right to work. Once you are of a certain age, you have the right to work. The government, the state would provide you the right to work. And the second right is the right to a decent burial. That means if you die, it is the responsibility of the state to bury you. That's it. These are the only two fundamental rights that are mentioned in the Chinese constitution. You can understand the nature of rights that are there. The nature of rights. In India, you would find the rights that we have. The rights that we have, it ensures, because the rights that are there, they are available to us. Those rights, the nature of those rights are such that it ensures the working, the functioning of a democracy. On the other hand, the nature of rights that are present in a country like China, you can, if you look at it, you would understand what the country is about and what is the nature of the, or the standards that the country follows. In us, for us, that is not the case. Right to work or right to a decent burial, you know, the parochial nature of these rights, it points out to the fact that there the state does not provide any substantive rights to the citizens. On the other hand, a democratic country like India, you would find the nature of rights, the nature of fundamental rights are completely different. It is there so that it ensures proper development of an individual. It also ensures that there is proper functioning of our democracy. Clear? And that is the very reason why it is called as fundamental rights. Not just because it is guaranteed to us by the constitution. Like she said, she put forward a very good point that these are protected by the Supreme Court. Supreme Court is considered to be the protector of fundamental rights. So can we say that that is the reason why it is called as fundamental rights? Yes, but not the only reason why it is called as fundamental rights. Not the only reason. Yes, these rights are obviously protected it is given to us by the Supreme Court, and the Constitution imposes a duty on the Supreme Court to protect fundamental rights of citizens. So yes, this is protected, but not the only reason why it can be considered as fundamental rights. It is considered as fundamental rights because it ensures overall development of an individual, and it also ensures proper functioning of democracy. And that is the reason why it is called as fundamental rights. Clear? Have you understood this? So whenever we talk about rights can be classified into these. There are some human rights that we have, and there are some statutory rights. Statutory rights can also be further classified into two. Statutory rights, what is the meaning of the term statutory? Legal, yes. Statutory means legal. So statutory rights that we have, this can also be further classified into two: constitutional and non-constitutional. Constitutional rights and non-constitutional rights. So constitutional rights are what rights? Those which are mentioned to us or given to us under the Constitution. Constitutional rights can further be classified into two: rights that are mentioned under Part 3 and rights that are mentioned outside Part 3. Rights that are mentioned outside Part 3. Example of non-constitutional right would be what? Right to information. Right to information is an example of a non-constitutional right. Nowhere it has been mentioned in the Constitution. Example of this would be what? As I said, right to vote. Right to vote. Or for that matter, right to property. And Part 3 of the Constitution has 6 fundamental rights. Part 3 of the Constitution has 6 fundamental rights. What are those 6 fundamental rights? First is right to equality. Right to equality is mentioned from Article 14 of the Constitution to Article 18 of the Constitution. It deals with right to equality. Second, right to freedom. So, which article deals with it? Article 19 to Article 22 of the Constitution deals with right to freedom. What is the third right? Right against exploitation. Article 23 and Article 24 deals with rights against exploitation. Fourth, right to freedom of religion. Article 25 to Article 28 deals with right to freedom of religion. Fifth, yes, educational and cultural rights. Article 29 and Article 30. And the sixth, right to constitutional remedy. Right to constitutional remedies. It has been mentioned under Article 32 of the Constitution. Clear? So these are the 6 fundamental rights that we have. So human rights. Certain rights we enjoy, all of us enjoy. There is no discrimination. Any individual who is residing in India is a human. No discrimination, whether he is a resident, whether he is a citizen, alien, doesn't matter. All individuals will enjoy certain rights. These rights they enjoy because they are born as humans. Clear? Some of them may not be statutory in nature. Matlab, some of them may not be legal in nature, but they enjoy these rights. They enjoy these rights. Important thing is that this right that is there, it is not just available to those individuals who are currently present. Even those individuals who may be later on may be born, they also enjoy these rights. Like when we talk about the right to a clean environment. So this environment does not belong to us. No, we have to leave it. This resource that we have to leave this resource considerably for the upcoming future, the future generations. They also enjoy certain rights as they are human rights. Some of the rights are legal, statutory. What does that mean? It means there is some legal definition that the right has. Clear? So when we say statutory, it means there is a law for it. Like the Constitution may be a law. The Constitution is in itself is a law, and there are some non-constitutional, which means it is legal but it is not mentioned in the Constitution. When we say constitutional rights can further be divided into 2. Those rights which are mentioned under Part 3 of the Constitution, fundamental rights, and those rights which are mentioned outside Part 3 of the Constitution, like right to vote, right to property. Right to property previously was a fundamental right. Later on it was amended and it was made the part of Article 300A of the Constitution, right to property. We have the right to property. It is a constitutional right, but it is no more a fundamental right. Similarly, right to vote, it is a constitutional right, but it is not a fundamental right. Clear? Understood this? Give a subheading, right? Nature of fundamental rights. We may or may not. हमेशा legal नहीं होता है. We may or may not. Like when we talk about UN conventions, there is a UN convention on human rights. There is a human convention on human rights. Clear? So it may or may not be protected under the law. In India, we do not legally recognize the term something called as human rights. We do not recognize it. हम recognize करते हैं only statutory rights, rights which are legal. We do not recognize the term human rights. Clear? And there are various reasons. Later on, you would find that in the course of your preparation, you would find there is a problem with this idea of human rights. What we consider to be human rights and what is considered to be human rights by the Western world or the rest of the country, rest of the world, that may be different. That definition may be different, and that is a problem as well. So this idea does not have what you can say in India. It does not have statutory recital. It does not. It is not legally recognized. What we recognize is this. Clear? Nature of fundamental rights. First, fundamental rights are individual rights. They are individual rights, except, they are individual rights, just write individual rights, which means you enjoy these rights as an individual, as a citizen. You do not enjoy this right as only as a group. Every one of us have fundamental rights. We don't have fundamental rights because we are there in a group. We all have fundamental rights. It is enjoyed by us as an individual. Clear? Second, they are enforceable rights. They are enforceable rights. That is, they are enforceable against the state. They are enforceable against the state except right against untouchability, right against untouchability, and right against exploitation, which are enforceable against the state and individuals, against the state and individuals. Clear? Underline this: right against untouchability and right against exploitation. Very important. This is very important. See, generally, if you look at the language that is there of fundamental rights, you would find that these rights are available to us against the state. The basic nature of fundamental rights is that these rights are given to us so that we do not have an unlimited state or a totalitarian state. समझ रहे हो? एक exploitative state existence में नहीं होगा. If we have fundamental rights, like if we have a fundamental right against any kind of discrimination, and we have fundamental rights to equality, which means you cannot be prosecuted just individually. That okay, state का मन किया तो मुझे punish कर दिया, बाकी सबको छोड़ दिया, मुझे punish कर दिया. That is what? That is an example of an exploitative state, a state which is detrimental to me, my rights. That state we cannot have. Unlimited state is not there. The state is prohibited to take up certain actions. So these rights that we have, these rights ensure that what is in existence is a limited state. हमें state चाहिए. We want a state, but state should have limited powers. The state should not be present everywhere. The state should not, the state should not take up activities which are which may be detrimental to my something that is personal to me. I don't want that. I don't want the state to be present in my house. मेरे घर में मैं कैसे रहता हूं, I don't want the state to be present there. That is something that that is completely, that is absolutely personal to me. If the state is present there, what do we have? What do we get? We get an unlimited state. एक state जो हर जगह present है, unlimited. Its presence is omnipotent, unlimited. That is not the kind of state we desire, because if that state is what we get. If that is the state that we have, what happens is it becomes exploitative, it becomes totalitarian. All powers absolutely concentrated in the state. We don't want that kind of a state. And hence, these rights that are there, it is available to us against the state. When we talk about right to equality, you would find that right to equality, the language will always be in this manner. The state is prohibited to discriminate. It would always be against the state, except for the right against untouchability. It says no individual, neither the state nor an individual can practice untouchability. It's not that it is only the state is prohibited to take up untouchability. Even I cannot practice untouchability. If I do that, it is a punishable offense. Similarly, right against exploitation, that is Article 23 and Article 24 of the Constitution. It is available to us not only against the state, it is also available to us against any individual. Like if we talk about Article 24, it talks about child labor and prohibition of child labor. So child labor is prohibited not only because child labor cannot be taken up by the state. The state cannot employ children. Even we as individuals cannot employ children. Similarly, Article 23 of the Constitution prohibits involuntary labor. So not only is it that the state cannot take up involuntary labor, even I as an individual, I cannot force an individual to work for me. Involuntary, that cannot happen. So all these rights that we have, all these fundamental rights that we have, they are justiciable rights, which means if they are violated, I can approach the court. And the court, to protect my fundamental rights, will give certain decisions, ensuring that my fundamental rights are protected. That is what is meant by being justiciable. And justiciable against whom? All these rights that we have, they are justiciable against the state, except for the rights against untouchability, which is justiciable not against only the state but against everyone, even individuals. Similarly, right against exploitation, available to us not only against the state, it is also available to us against the against every individual. Clear? So remember, these rights are generally justiciable against the state. It is prohibited so that the state cannot become, or the state does not become, an unlimited, exploitative, totalitarian state. Clear? Third or next. Fundamental rights are negatively worded and are called as negative obligations of the state. Why negative obligations? The state shall not. Every fundamental right that you would find, you would always read it in this manner. The state shall not. Language agar aap padhoge, language is this: the state shall not. When you say shall not, which means what? It is negative obligation. It prohibits the state to do something. So it is considered to be negative obligation of the state. And the last point you can write here. They are not absolute rights. They are not absolute rights, which means they are under reasonable restrictions. You can write here, they are not absolute rights, they are under reasonable restrictions. They are under reasonable restriction. See, this is what we don't understand. Whenever you look at, whenever you are reading newspapers, specifically if you read newspapers such as the Hindu, you would find this is the case. They do not, despite the fact that we know that fundamental rights that we have, they are not absolute in nature, we tend to present it in such a manner that fundamental rights are absolute. No, they are not. They are under reasonable restrictions. Reasonable restrictions, the name itself, reasonable restrictions. Restrictions kuch bhi ho sakta hai till the time it is reasonable in nature. If it is unreasonable restriction, then the court comes in. And if the state comes up with any kind of restriction on any of rights that we enjoy, and if we enjoy these rights and it comes under unreasonable restriction, we always can question it in the court of law, in the Supreme Court, and the Supreme Court takes up decisions in this regard. Like in the last few in the last few days and years, you must have heard about article section 377, homosexuality, the idea of Sabrimala case, then going back to Aadhaar was being challenged. Similarly, Supreme Court has declared triple talaq to be to be unconstitutional. All of these were considered. Why? What was the ground of declaring it to be unconstitutional? Because they are some unreasonable restrictions. Like in the Aadhaar Act, there was a provision which empowered the state. That if the state, when it comes to certain purposes, for certain security purposes, could use our Aadhaar or any information that is generated for it in certain cases, which is in for suppose national security, etc. It was declared unconstitutional by the Supreme Court. It was declared unconstitutional by the Supreme Court. Supreme Court declared Aadhaar to be constitutional, that fine, this is a constitutional idea, but certain provisions were declared to be unconstitutional. Certain provisions were declared to be unconstitutional. This is the reason. Any unreasonable restriction, Section 66A of the IT Act, in 2015 it was declared to be unconstitutional. Why? Because the manner in which it was used, it imposed certain unreasonable restrictions. There were two sisters in the state of Maharashtra. Both of them criticized when Balasaheb Thackeray died. So both of them had taken up some social media post criticizing that the whole state, the complete Mumbai was in standstill. They were not allowing things to work normally because of an individual who had died. So when she criticized this on a social media post, there was a case registered against her under the section 66A. It was challenged in the Supreme Court. The Supreme Court considered it to be absolutely unconstitutional. So the Supreme Court declared it to be null and void. Reasonable restrictions. Restrictions should be reasonable. What is the problem with her criticizing this idea? There is absolutely no problem. It is in fact a fundamental right that we have, freedom of speech and expression. So any kind of restriction should be reasonable. If it is reasonable, it is absolutely fine. It is absolutely fine. Like, people also questioned this idea of when a law against triple talaq was enacted. When triple talaq was enacted, when it was enacted, so you would find that there were sections of the society questioning this very idea on its constitutional validity. That people have freedom of religion that is provided to us as one of the fundamental rights, and thereby any practice that is in the name of religion you take up, in that is absolutely constitutional and the state should not interfere. Why would the state not interfere? Why would the state not interfere? Any such acts that is unconstitutional, if it is a reasonable restriction on the manner in which we take up certain practices, that is absolutely constitutional by the state. It is absolutely constitutional by the state. If the state comes up with certain acts, if you remember when we were discussing the idea of secularism in preamble, what did I say? Secularism in India allows the state not only to tell religion but also to help religion. Helping religion like Article 26, etc., etc. Similarly, when we say tell religion, so it tells religious institutions and religious denominations what are the practices that are constitutional and what are not. What are if it is a practice that is derogatory against someone, it is to be held unconstitutional. It cannot be condemned, and the state can by a law prohibit certain practices. So all the fundamental rights that we have, these fundamental rights are, they are available to us, but these rights are not absolute rights. They are under reasonable restrictions. All these rights are under reasonable restrictions. Clear? So this is the nature of fundamental rights. Sometimes, you tend to get a question in your prelims examination with the statement is, the fundamental rights guarantee which of the following? Options are social democracy, economic democracy, or political democracy. Answer to it is political democracy. If you want to write it here, you can write it. Fundamental rights guarantee political democracy. Fundamental rights guarantee political democracy. If you want to write it, underline it, remember it. They guarantee political democracy. In the course of our discussion, you would understand why it is something that guarantees political democracy. In course of our discussion, you would understand this very idea. Clear? Have you understood this? Now, see, before actually I start our discussion on fundamental rights, there are 3 or 4 ideas that I need to discuss before that. There is something called as amendability of fundamental rights. There is something called as judicial review, something called as doctrine of eclipse, and the 4th idea, something called as suspension of fundamental rights. So these are the 4 things that we discuss before we actually go into articles of, all the articles that are there under fundamental rights. Clear? Give a subheading, right? Doctrine of eclipse. हाँ. 2 बजे कौन सा क्लास है आपका? एंशिएंट हिस्ट्री. 2 बजे नहीं हो सकता आपकी क्लास? ओके, 10 मिनट्स. 10 मिनट्स. ठीक है. आई हैव टू कंप्लीट दिस बाय दिसंबर. ठीक है, मेरे पास भी लिमिटेड टाइम है बिकॉज फ्रॉम जनवरी. खैर, डॉक्ट्रिन ऑफ एक्लिप्स. Let's just understand what is doctrine of eclipse before actually we go into this idea of what constitutionally it means. Let's understand what this doctrine of eclipse is. For understanding doctrine of eclipse, you should also know what Article 13 of the Constitution says. So let's start with Article 13 of the Constitution. Article 13. Article 13. Article 13 clause 1 says, any pre-constitutional laws, any pre-constitutional law that is violative of one or more fundamental rights, any pre-constitutional law that is violative of one or more fundamental rights is to be held unconstitutional which means null and void. Null and void means not enforceable. To the extent of such inconsistency, to the extent of such inconsistency. which means any pre-constitutional law, obviously there were lot of laws that were made during the British India period and they were extended to India. These laws that were there, the objective, what was the objective of the laws that were made during the British period? The objective was to ensure control over the Indian government, the Indian people, and this control that was there, it was pointing out to that exploitative totalitarian state, and hence Article 13 of the Constitution declares that any such law which was present during the pre-constitutional era, that means before 1950, any such law that was present, but those laws are violative of or inconsistent with fundamental rights, one or more fundamental rights, those laws are to be held unconstitutional by the extent of that, what you can say, by the extent of that inconsistency. So whatever provisions of the law is inconsistent with fundamental rights, they are no more to be enforceable. They cannot be enforceable. Why? Because they are all violative of fundamental rights. Clear? Next, Article 13 Clause 2. Article 13 Clause 2. Article 13 Clause 2 extends the same provision for post-constitutional laws. Extends the same provisions for post-constitutional laws. That means any law that is made in the post-constitutional era, after the constitution has been enforced by the parliament or by the state legislature, any such law that has been enacted, but the law is contradicting one or more fundamental rights, the law is contradicting one or more fundamental rights, the law is to be held unconstitutional, null and void, ultra vires, which means no more enforceable. The term null and void or the term ultra vires, it simply means that those provisions of those laws would not be enforceable anymore. Those provisions would not be enforceable anymore. So if you go back, there were certain laws that were made in the British period which did not provide freedom of press. Certain laws that were there, they were discriminatory against certain sections of the population. Certain laws were implemented in such a manner that it discriminated among individuals. These laws that were there, it did not allow us to enjoy some basic rights that we had. So all those laws, because they are contradicting fundamental rights of freedom of speech and expression, freedom of right to equality, or any such fundamental right that we have, because they are contradictory, they are in contravention to them, they are not in consonance with those laws, they are automatically to be held unconstitutional. And similarly, if any post-constitutional law that is enacted by the Parliament of India or by any state legislature, if the law somehow contradicts fundamental rights, if they are not in consonance with fundamental rights, they are contradicting fundamental rights, they are inconsistent with fundamental rights, those laws are to be held unconstitutional. That means those laws are not enforceable. They cannot be enforced. Those laws are to be held as unconstitutional. This is what Article 13 of the Constitution says. Clear? This is what Article 13 of the Constitution says. If you look at these two provisions of the Constitution, what is meant by this? What is the consequence of Article 13 of the Constitution? What is the consequence? To safeguard the basic structure of the Constitution? No. What does Article 13 of the what is the consequence of it? Yes? Judicial review, yes, absolutely correct. One idea that he says is an idea of judicial review, absolutely correct. Anything else? It means that is the idea of all of the fundamental rights. It simply means fundamental rights are supreme rights. It simply means this idea. It is supremest. No, it is supreme than any other rights or any other law. It cannot be taken away. It is Article 13 of the Constitution which ensures that those laws which are contradictory to what fundamental rights say, those laws are automatically to be held as unconstitutional, not enforceable. And how it is to be done? As he said, absolutely correctly he put it, through the mechanism of judicial review. It is through the mechanism of judicial review. Clear? Now, what is the idea of doctrine of eclipse? I'll be discussing that tomorrow because you have a class from 2. And no, I'll have to talk because I was informed that class 2 बजे तक है, तो मैं देखता हूँ, ठीक है.